Welcome back to another chapter on the North Carolina Real Estate Exam Prep. This is chapter 17 on fair housing. If this is your first time, welcome. If you've seen some of my videos before, thank you so much for subscribing. I have definitely taken notice and I'm very appreciative. If you have not signed up for real estate courses yet, grab your 10% off link down in the description below for new signups. And let's get into it. Violating any of the upcoming Fair Housing Acts is a criminal violation and goes both against licensees and clients. It's really important to look at and understand these concepts. It is against the law to discriminate against anyone based off their race or their color, and this is covered underneath the 1866 Civil Rights Act. And this isn't a real estate act, this is just a general law, and I'm not your mom or your dad, but you should probably be practicing this in your personal lives anyway. The 1968 Fair Housing Act does apply to real estate. This prohibits discrimination in home transactions, all advertising, finances, services, or getting like special treatment, and appraisals. The Fair Housing Act originally covered race, color, national origin, and religion. In 1974, gender was added to the protective classes. And then in 1988, handicapped and familial status, like how many kids you have, were also added. Now you'll notice there is no mention of income in the protective classes. So you can't be a racist, but you can be a classist. I'm completely kidding. Look, you can refuse to rent, sell, or lend to someone based off of their poor credit or their lack of proof of income, but the type of income, as we mentioned in the previous chapter, cannot be judged as long as it is provable source of income. You also can't refuse housing to someone who is under Section 8 or to someone who doesn't have a job as long as they have proof of income. When working with sellers, you must never advise that client to move out of a neighborhood because of a certain type of demographic. An example would be you telling your client, "You should move out now. Do you see who's moving in a few houses down?" Back when I lived in Texas, we would always joke about moving out of the city limits of Austin because Californians kept moving in and raising the prices. And while Californians aren't a protective class, and I wasn't having these conversations directly with my clients, I was okay. But had I mentioned moving out of the Austin city limits because a protected class was moving in, that would not be okay. This whole concept is called blockbusting and deals more when working with sellers. When working with a buyer, the term steering refers to directing your buyer towards or away from a certain part of town or a certain type of demographic. You wouldn't want to live in that part of town is an example of something that you shouldn't say. Redlining is when you change the terms of a loan or refuse to give a loan at all based off the color of someone's skin or other protected demographic. This is more for lenders, but you should still remember it. A lender also can't charge more or less based off of the location or part of town the house or property is in. There are some, of course, exclusions to all of the acts that we just discussed. If a home is owner-occupied, they can choose who they want to rent it out to and who they want to live with. Religious buildings can also determine who they want to rent out to. Private clubs and nationally, for sale by owners are also exempt from those acts. But in North Carolina, hard distinction there. In North Carolina, there are no exemptions for sale by owners. Now we'll get into disabilities, and these can either be physical or mental. Common accommodations are things like reserved parking spaces, rent reminders, allowing live-in caregivers, and providing larger fonts for the documents and contracts. As a landlord, you must allow for all reasonable modifications. These are typically paid by the tenant, and when the tenant moves out, it is the tenant's duties to place everything back to how it was when they found the property. An example here would be a handicap ramp into the entrance of a home. And we discussed this in the last chapter, but service animals cannot be excluded, and a landlord cannot charge extra fees for that animal. As for the other 1988 amendment, familial status, this is another protected class. Prior to this amendment, the majority of women were actually denied housing just because they had children. Today, landlords can no longer do this, so children are essentially taken out of the equation when it comes to these home sales transactions or rents. There are also familial exemptions when it comes to senior communities, but certain requirements must be met. The rules are as follow. If a community is a 55 and older community, 80% of the units there must have one person in the household that is 55 and older. And a community that is a 62 years and older community must have 100% of the residents must be 62 years old or older. All of the fair housing laws discussed would be a criminal violation if broken. These are enforced by HUD, private agencies, and the Attorney General. A minimum fine is $10,000 and a maximum fine is $100,000. When advertising houses, and this would be a great section for you to actually read in your book, it's the first time I've ever recommended that, you cannot advertise and target certain demographics. For instance, when I run my Facebook ads to get buyers, I can't run one ad towards an older demographic and another ad towards a younger demographic. Not only is this against the rules, Facebook will literally block your ad from going public because they know it's real estate and they know that you cannot target certain demographics, especially based off of age. There are other rules you should read up here on your book, such as what you can write in your actual listings. I'll be honest here, this section got me when I was taking the test. Another example is, and I believe this was a test question, is you can't write in a listing description that something is within walking distance because it is prejudice against people who are in a wheelchair. I see walking distance all the time, but it is technically wrong. The problem to me here is though, where does that line stop? Because you can still use view of the lake, but there are blind people. Eventually, can we no longer say beautiful kitchen because someone might be offended by your interpretation of beauty? A large bathroom may be small to the people the size of Shaquille O'Neal. So where do descriptive terms stop? For the test though, in 2020, walking distance is not allowed. So the Equal Credit Opportunity Act, as we've discussed previously, prohibits discrimination on credit based off of race, color, religion, national origin, sex, marital status, age, or public assistance, which we've touched on that before. And this it applies to lenders. And then again, remember, in North Carolina, the Fair Housing Act is not exempt for sale by owners, like it is nationally. Any complaints filed must be done within 1 year. If you're a victim to any of these acts, you have 1 year from that time to file. And lastly, when transferring a property, a seller is not at all required to make any of the accommodations for those that are disabled. But a buyer might ask the seller to fix some of those or make some of those accommodations because the lender will sometimes require those accommodations to be done. Of course, the seller can refuse. And that's all there is for Chapter 17. Let's do a quick recap. Violating the Fair Housing Act is a criminal violation and can result in a $10,000 or a $100,000 fine. The 1866 Civil Rights Act is a general act that says you cannot discriminate based off of race or color. The 1968 Fair Housing Act is a real estate act and protects people that are based off of race, color, religion, and national origin. Gender was added in 1974 and handicap and familial status was added in 1988. You can't refuse housing due to the type of income someone has, whether they have public assistance, existence of criminal arrest, or existence of employment at all, as long as they can prove their income. Blockbusting is more towards sellers. You can't advise someone to move out because of a certain type of demographic moving in. Steering is more when working with buyers. You can't advise a buyer to not live in a certain part of town because a certain demographic lives there. Redlining is when terms are changed on a loan because of someone's race. This is more of a lender thing. Owner-occupied rentals are exempt from these acts. They can choose who they want to live with. Same with religious organizations and private clubs. Service animals can't be excluded and a landlord cannot charge for them. Accommodations for disabilities are mandatory, and modifications for accessibility are typically paid by the tenant. Landlords can't prohibit children and can't deny a mother just because she has children. A 55-year and older community must have 80% of their residents be 55 years or older. So 80% of the units must have one person that is 55 years and older. A 62-year and older community must have 100% of the residents be 62 years or older. When advertising, you cannot target protected demographics. And that's it for today. We made it through another one, and these next 3 chapters are literally just a few pages long, so you're basically at the finish line here. Again, I'll have some math review videos coming up after I finish these next 3 chapters, so remember to subscribe so you don't miss out on some of those. I'd also really appreciate if you gave this video a thumbs up. It really helps with the YouTube algorithm. Thank you so much, and I'll see you soon.